Okay, our next case is in re amendments to Florida Rules of Civil Procedure, and it's case number 2023-0962. Mr. Edwards. So now we get to the easy stuff.
Mr. Chief Justice, may it please the court. Tom Edwards, and I'm here individually. I'm a prior member of the Workgroup and now a member of the Rules of Civil Procedure. I raised concerns in my comment about the need for enforcement mechanisms which were not included in the original versions of the discovery changes to the discovery rules. Most of those are now remedied with the new proposed 1.380, but not 100% of them. And we have now incorporated into 1.380 some of the additional provisions from the federal rules that would mimic what is in Rule 37. The one outstanding issue relates to Rule 1.280, and it is the certification sanctions if a lawyer is certifying discovery with their signature and have done some things improper, either the party or the lawyer. And that is actually underway with the committee. And it has already been voted on once, and I've conferred with the chair, and that can be expedited. He'll be speaking to that in just a few moments. So it is on the cusp of being passed, and that would address all of the substantive concerns that I raised on the need for rule changes. There are a couple of additional issues. Number one, I do think it's very important to have these enforcement mechanisms. I am not a fan of sanctions. I don't think lawyers should be sanctioned for doing their jobs and advocating things appropriately, particularly on close questions. But there are instances where sanctions are needed when people are not providing discovery as they're expected to under our rules. At page 18 of my comment, I gave case law that dates back to 1947 from the U.S. Supreme Court and multiple cases from this court that explains why the open and proper exchange of discovery is essential to the efficient progress of cases through our court system, and it helps the efficiency of cases resolving when they should if it can be done earlier in the process. So these enforcement mechanisms that are now in the works are really important. The one other issue that I was going to touch on is somewhat controversial, and that is the advisory notes from the federal rules as it relates to discovery when we're now changing the basis for discovery in our rules and some of the enforcement mechanisms. Traditionally, our Rules of Civil Procedure Committee opposes having comments and advisory notes because they are not the law. The law is set by the court and the rules. But as we're embarking on this, and we're embarking on new sanctions rules and new rules for what can be discovered and proportionality, it's important for lawyers and judges as quickly as possible to be able to get up to speed on what their obligations are and what the standards are. The advisory notes that are in the federal rules, and they are in some instances extensive. I think the notes for Rule 26 span 34 or 36 pages, and they're single-spaced, they're dense, but they're also very helpful in giving guidance to judges and lawyers. And I gave examples of this in my comment. At page 14, I give an example of a very important change in the rule that omits language that used to be in the rule, Rule 26, that we're now adopting. And the reason it was omitted is not because these things are no longer discoverable. The example I give at page 14 of my comment explains that this is now so embedded in the law, we don't need to have instruction in the rule anymore that this stuff must be provided, but it's still stuff that is supposed to be provided because there's lots and lots of case law that says that in the federal system. And so that, if you look at the example that I'm giving, it's only one example of many other instructive devices that are in the advisory notes that will be helpful to lawyers and judges in doing things properly and efficiently in our system. I think I also give an example at page 12 of my comment where when you passed the summary judgment rule recently, you added a comment that referenced some of the federal law. You can do the same type of thing as it relates to the changes in Rule 26 and the changes to Rule, or not 26, 1.280, and the changes to Rule 1.380, so that lawyers in our state have that as advice, and judges in our state have that as advice to help them understand what their obligations are. And it can be made clear in the comment that that's not the law, but it is there as an assistive device. I've really covered the issues that I think I needed to cover based on my comment. I do want to tell you that I know in the past there have been times when the court perhaps felt the rules of civil procedure was not moving things efficiently and as quickly as perhaps the court needed. I can tell you that with these rules, they have been bending over backwards. I've been a participant with them in it, and we have had meeting after meeting, some going into the evenings to get all this done and get it done efficiently. And I know that our leadership has really stressed getting things done timely and efficiently. And the conversation I had this morning is that we can get this done with this one additional piece that's still outstanding on Rule 1.280.
I have just one comment, one question,
Yes,
and I appreciate the work that the committee has done, and I appreciate the court's involvement in creating a rule, in creating the structure, in the way litigation takes place, and in today's legal world. One thing that you mentioned in your comment that struck me on the issue of proportionality. And to be expected, I believe, if my experience tells me that we're going to get a lot of boilerplate objections, objection proportionality. You'll get that kind of thing. And you suggest that the only way to stop that is sanctions. And you mentioned that we have pretty much covered the sanctions in the rule already, but I think you suggest that there should be a specific sanction in a proportionality rule for such type of behavior where they're going to make just an objection to that. Because I mean, if you think about it, if our purpose is to move things along, well, I see in proportionality a big black hole where that objection is made, and I'm trying to figure out how does a judge handle it. When you come before me and there's a proportionality objection, how do I decide whether it is basically, you're asking for too much for this little case, slip and fall case, and now you want, the financial records of the corporation. I mean, how do I decide, as a trial judge, how do I decide whether something is not proportional to the case?
It's going to require digging into the advisory notes and the existing federal case law if you all are going to do something similar to what you did in the summary judgment rule and recommend that the judges look at the federal case law on these issues. The federal judges have been pretty conservative in applying the proportionality rule, and there are devices, including the note that I referenced from page 14 of my comment, that recommends methodologies for dealing with some of those issues, such as now in electronic discovery, which we're confronting more and more and more. We now have electronic medical records and audit trails and things of that nature. What the particular comment I referenced, even though the language has been taken out of the rule, recommends that there should be initial discovery on what is the audit trail mechanism that's used. Give us the list of all the audit trail materials that are available. Give us initial information about what is there, so that both the judge and the opposing attorney can now look at how we narrow it and what is legitimately related to the case.
In federal court, the judge will deal with that back in his office and issue an order. Now, in trial court, my concern is it going to require a hearing?
Actually, and that is, and I don't want to blow by it, I did touch on this. I did not reiterate the concerns that were expressed previously in the prior oral argument and in the work group's report. I do continue to have concerns that our courts don't have the resources to deal with some of the problems that will be coming dealing with discovery. In federal court, the district court judge has 2 or 3 law clerks, and there is a magistrate typically When a federal court discovery dispute occurs, it's referred immediately to the magistrate, and the magistrate is dealing with it within a month. And as soon as the briefing's done, you're called in and it's dealt with. In state court, it takes 3 to 6 months, depending on what judge you're in front of, to get a hearing on these kinds of things. And that is going to play havoc with the trial order when it impacts stuff that's necessary for depositions and presentation at trial.
And these proportionality objections, they can come up in the middle of a deposition.
I suspect we're going to be seeing the same kinds of things we see a lot of times now with interrogatories and requests for production, and that is standardized objections and proportionality is going to be listed in there. And I just had this happen to me within the last 2 to 3 weeks. They listed a string of standardized objections in a federal court case, listed proportionality with no explanation of what the proportionality objection was. I then respond, and in federal court, they file their objections. I have to then file my motion to compel. They give me no information on what the proportionality objection is and what it's based on, and they then respond to it and attach a declaration from their client. And in federal court, I now don't have the right to a reply. I'm now going to have to ask for a reply now to deal with proportionality for the first time, knowing what their real objection is. And that's what I fear we're going to be seeing in the near future with this kind of stuff.
So in state court, instead of all the back and forth pleadings, you would just schedule for a hearing?
You'd have to, and if it's happening like frequently happens now, you're going to get a long list of objections with no true explanation of what the substantive basis for it is. With a proportionality objection, there should be a basis provided with it at the time of the objection, but that rarely happens.
So what happens to your case as far as moving along to get into trial? If you get caught up in one of these proportionality, many objections in the middle of litigation?
If you're not getting the documents that are necessary then to move forward with your depositions, it's going to impact all the deadlines.
There you go.
So, I am happy to answer questions if there are any further, but that really covered. I do want to add one thing. Judge Moe and I discussed one issue related to the continuance rule right before this started that I think she's going to touch on, and I am supportive of it and have seen some of the same problems I think she's going to discuss.
Thanks a lot. We appreciate it.
Thank you.
Cosme Caballero on behalf of the committee. I want to quickly touch on an issue Mr. Edwards mentioned about 1.20K. It is true we are moving quicker these days, and just as a housekeeping matter, the committee has voted to eliminate the 2-vote requirement so that we can move things a little bit faster. And that's all working in progress, but it has its procedure. With regard to 1.20K, I would mention what Mr. Edwards has suggested. And the current rule, by the way, 1.280K, as drafted by the court within its opinion, basically has all of Federal Rule 26G. It's just missing certain components. When this came up from the commenters, the committee went back on an expedited fashion, looked at it and said, look, it really should belong there. Let's go ahead and do that. And we have language that's ready to go. We can provide that to the court on an expedited basis. We can provide the minutes with the language of the first vote that shows what it should look like. And it basically takes the language from 26G. It applies the right cross-references. It has everything correct for the rule. And so we can make that happen very quickly. With respect to the advisory committee notes, I know it's well-intentioned, but that really has no place in our rule set. Can you have a comment like you do in the federal, in the 1.510 that references says, look, we're adopting the federal summary judgment standard. You can look at the case law dealing with that particular standard. Sure. I would say try not to add language into the comments because different judges look at those comments and committee notes differently. They look at some of them see it as binding, some of them don't see it as binding. I would mention that the advisory committee notes from the federal system, they are useful, they do provide guidance, but Rule 26G, where you're talking about committee notes that span from 1970, amendments spanning from 1970 to recently. You're talking about 10,000 to 20,000 words of content. They get used for guidance anyway within our system. Everybody knows our rules are modeled on the federal rules. Judges every day deal with arguments based on advisory committee notes. I would urge the court not to adopt and transfer committee notes from Rule 26 into our 1.280. It's ultimately going to cause more problems and more confusion. You also have the issue of if you have those notes in 26 and 1.280, but you don't have it in other rules, are the advisory committee notes for other rules somehow not have any effect? So I think it's not a good idea. The committee generally does not view that as a good idea. I want to transition to proportionality. I really don't have anything philosophical to say about it. I just want to talk about what tools we think will help implement it. Mr. Edwards is right. Proportionality in the federal system, for anybody that's been involved in it, it generally encompasses discovery disputes involving tremendous amounts of data, tremendous amounts of information. You're talking proportionality comes up in multi-district litigation. It comes up in very significant disputes. As written, it will apply to small cases. It will apply to cases that maybe this shouldn't be an issue, but it's going to be an issue. So what we want to do is create, as a committee, is create tools that help facilitate that process. Specifically, we provided the court, we filed it as a separate report to the court. It was case, I think, 2024-1385. The court recharacterized it as a response to comment in this court. And what we proposed were to bring into Rule 1.340, the interrogatory rule, bring into 1.350, the request to produce rule, the language from the corresponding federal rules, 33 and 34, that requires specificity with objections. We don't have the analog right now in our rules. I would urge the court to adopt those. We also implemented into and amended, or proposing an amendment to 1.350 that requires when a responding party is going to withhold documents based on an objection, they have to say they're doing that, as opposed to just keeping everybody sort of in a limbo state. This will provide transparency. It'll facilitate the conferral process. Greater transparency in the objections is better for conferral. I would urge the court that if you do adopt those, and we strongly recommend you do, it was unanimous with the committee. We have a judicial input subcommittee that I appointed 17 judges from each circuit, from the 20 circuits. We're missing 3. Hopefully we can get some folks to join in. But it was unanimous with those folks. Everybody wants this. I would urge the court, if you do adopt it, put in your opinion strong language that generalized boilerplate objections are not sufficient. They're not what should be done. I think that would help the process. With respect to 1.380, we also brought in from Rule 37 the provisions dealing with what happens when somebody doesn't comply with the initial disclosure obligation, what happens when somebody doesn't supplement discovery, which are now part of what 1.280 has. That needs to be there. Honestly, I think what happened in the process of drafting all this, the 1.380, 1.340, 1.350 were not part of the court's referral. They were kind of outside the scope of what the committee was looking at and may have just kind of fallen outside the loop. We went back, looked at it, realized based on a lot of the commenters and folks looking at this that it is appropriate to add those provisions, and I think they work to hand in hand with these obligations that the court's imposing with initial disclosures and supplementation. So we would urge the court to adopt those changes that the committee is proposing, specifically the ones from our report in 2024-1385, which are now part of this case. And then I would urge the court, as Ms. Luca mentioned, 1.380 has a conferral requirement, as everybody knows, within the motion to compel section of that rule. Now that's not going to be so. That conferral requirement should be eliminated in favor of just leaving the one conferral requirement from 1.202 so you don't have inconsistency. The same is true for the 1.460 continuance rule. That has a conferral component. I just mentioned that now. I know it's outside the scope of this, but that needs to be eliminated too so that there's consistency. Thank you.
Thanks, and we really appreciate all the work the committee's been doing. We know that we've been generating a lot of work for you guys on top of everything else that you're doing, and we really appreciate the spirit of cooperation and the thoughtfulness of the comments and everything.
Yeah,
So
you're
thank you
welcome.
very
We're here
much.
to serve, so whatever we can do, we'll do it.
May it please the court. I have just a couple quick thoughts on multiple provisions. I'll go in order of the rules. 1.200D3 and E1 have a theoretical conflict. I feel very strongly that the way to resolve it is to delete 1.200D3 in favor of just having E1, which says deadlines in a case management order must be strictly enforced unless changed by court order. I think that is the most succinct and direct way to state the necessary principle. Regarding 1.200D2 and 1.200B, I think a comment filed by David Caldavilla, Braxton Gillum, and Kenneth Scher has a very good point, which is that 1.200B says that a court has 120 days after a complaint is assigned to assign a case track. But 1.200D2 says that a court has to issue a case management order, which has to include the assignment, within 120 days of filing or 30 days of service, whichever is earlier. So B says you have to assign the track within 120 days, but D2 says you have to issue a case management order theoretically within 30 days, but you can't do that unless you've assigned the track. So basically you have more time to assign a track than you do to issue a case management order, but the case management order has to include the assignment of track. They're inconsistent. I think Mr. Cadavilla's suggestion is not my suggestion. Mine is that the realistic thing to do is to make it 120 days from filing, because I don't see a universe in which judges have the capacity to babysit their dockets to look for a notice of service. They don't know when 30 days has passed since service. Just make it 120 days from filing. And also, there are Hillsborough, Miami-Dade, other circuits are working on having automated procedures. So let's strive for realism. Mr. Scher and Mr. Caldavilla also had a very good point, I believe, that the case management rule requirements for extending a deadline could be read to conflict with 1.090B. 1.090B is the one where I say, Your Honor, I have a very heavy trial load and I need 10 extra days to respond to a motion for summary judgment. The case management extension rule is where you have to explain what the date is that you need to have moved, what you're going to do to make it happen. You know, my expert got sick, therefore we need the deadline for expert disclosures extended. We have confirmed that he is available on X date. Opposing counsel does not oppose this motion. There were very specific requirements. To ensure that there is no conflict and that there is no confusion, I would propose that you create in 1.090B, that you create a section 3, have it say applicability. This rule does not apply to moving deadlines in a case management order. The proper procedure for extending such deadlines is contained in Rule 1.200E. Ta-da! It's very clear. I also agree with Mr. Caldavilla that, and this was at page 10 to 11 of his comment, that judges should be able to hear a motion for summary judgment at a case management conference if there is time and both parties stipulate. That is the key. When the summary judgment, when the committee created the rule that said that if you want a case management conference, the price of admission is that you have to give the judge a list of all of the pending motions. Even if that's not why you're there for the case management conference, it's a case management tool for the judge, so they could look at it and say, okay, this case is 120 days old. Why is there a motion to dismiss that's still pending? Let's get that heard. And the rule says that if there is time, that the judge can order the parties to come to the case management prepared to argue it. You have to give the parties notice, due process. But we said that evidentiary hearings and summary judgment hearings or summary judgment motions could not be ruled on at a case management conference because those tend to be more involved. I see Mr. Cadavilla's point, which is if the parties really want the court to rule on it and both parties agree and there's time, then the judge should be able to. So I suggest that you consider making that change. In 1.201, which is the complex case rule, I think that you need to reorder. I think you need to have complex litigation defined as your letter A. And then I think you need to change letter B so that it is moving to designate a case as complex. It's way too complicated to try to explain to you in words. It's in my comment at page 11. That is where actually, it's at page 10 of my comment is where that section starts, and I would really strongly encourage you to consider that. 1.280K is something that I caught the typographical error in my comment, but my comment actually had an error, so I'm flagging it. Please, this is important. The Civil Rules Committee, after I filed my comment, we met, we saw it, we agreed that this is something that needs to be changed. You'll be getting that in a filing after it gets approval from the board. But what it needs to say is that every disclosure, not just discovery disclosure, every disclosure under subdivision A needs to be supplemented. That's on page 16 of my comment.
What is that? What is that rule again? The
1.280
subdivision.
1.280K.
Thank you, Justice Corio. On proportionality, I would ask that if you are going to adopt it, that I have no idea how the sausage gets made on this one, who looks at your Florida Supreme Court standard interrogatories, but these rules apply to county court cases. And if in county court you've got somebody who had a slip and fall and they're looking for $10,000 to cover their medical bills, I would point you to two examples. Florida Standard Interrogatory number 16 is list the name and address of every physician, medical facility, or healthcare provider who you've seen in the last 10 years and state your dates of examination and treatment and the condition for which you were examined. In that case, if we're going to have proportionality, that's not going to be proportionate, but because it's a Florida Standard Interrogatory, then it's pretty much rubber stamped that you need to be answering it. So food for thought that perhaps you want to re-examine or somehow soften whether those are standard for all cases. I also want to address a comment by Judge Huey regarding 1.280. I agree with him that we need to add the word economic as a qualifier in Rule 1.280. Are you ready? A1C. I think that's a medication. It says that the parties have to disclose a computation for each category of economic damages claimed by the disclosing party. His point is, please just make my life easier, put the word economic there so I don't have people coming in and arguing that they have to do non-economic too, because there's just no way to quantify in an initial disclosure what non-economic damages are. Judge Huey also asked that expert opinions have to be supplemented within 10 days of the expert providing the opinion. I would recommend against that because state court isn't like federal court where you have to submit a report. It'll turn into a game about when your expert gave you the opinion. I understand where Judge Huey's coming from. He's trying to move the process along, but I don't see that one being beneficial. Judge Huey also asked that all videos and photos taken by a party or agent at the accident or incident scene, regardless of when they were taken or by whom they were taken, be required to be disclosed. And the input that I would provide on that is that if I hire a consulting expert and I ask the consulting expert to go to the scene, the consulting expert is my agent, but anything that the consulting expert does is privileged. So under Judge Huey's proposal, I would have to turn over privileged information. So I don't recommend adopting that particular one. Again, I understand where he's coming from, but I think the way that he proposed it would work a lot of mischief, and it would actually wind up in some instances being contrary to the law. I agree with Mr. Edwards that it's useful for people to know, and I think to address Mr. Caballero's concern, perhaps the court could add a comment to Rule 1.280 that says something to the effect of, when this court adopts a federal rule, it intends to adopt the federal committee notes and case law and body of case law that accompany the rule. Short, simple, and I believe that's exactly why you ask to use the federal rules. Deborah Ingraham made a suggestion of requiring a HIPAA release for every healthcare provider as part of the initial disclosures. If you listed a healthcare provider in response to an interrogatory, she wanted a HIPAA release to be required to be provided. I would point you to the interrogatory that I just read to you. If every DCA in this state says that when it comes to medical records, if it's not relevant to the case at hand, it is protected by Florida's constitutional right to privacy. If I have to tell you every doctor I've seen in the last 10 years, and those doctors have nothing to do with my injury in this case, you should not be allowed to have a HIPAA waiver that would get you those medical records. So I understand her goal, but I do not think that it is a good idea. I reserved 3 minutes, and as usual, I went too long. I promise I've got 2 points, and I'll just hit one. I'll do the other one in rebuttal. CJE. On Rule 1.460, I know Judge Moe is going to talk to you about this, and I am so grateful for it because you can hear it from a judge in the trenches. I am worried about discretionary jurisprudence because I have personally appeared in front of multiple judges, and I have heard trial lawyers tell me that they are appearing in front of judges who are saying, the Supreme Court says I can't grant a continuance. And to that, I want to scream, no. I chaired the committee that wrote that rule. That is not what that rule says, and that is not what the Supreme Court is saying. I would strongly encourage you to, much like you did with the ethics rule for attorneys, create a mandatory CJE. And Justice Labarga, if you're still in charge of CJE,
No more.
Not your circus, not your monkeys.
No more.
I don't know who's doing it, but whichever one, make that one available via Zoom. Make it something that they have to take within a certain number of days of the case, of the rule becoming active. Make it, if we're going to potentially move the active date, make it something they have to do beforehand. But please have it taught by DCA judges who are former trial judges, because they will be the ones interpreting what the judges do when they are appealed. And having served as a trial judge themselves, they can empathize with what that feels like. But I think that you want to have a mandatory CJE so that the judges who think that you're saying that you can't grant a continuance know that what you're really saying is, if you're lazy and you haven't touched your case in 18 months, you don't get a continuance. If there is some reason that your case can't get to trial and you've been working diligently, then that's a different scenario, and the judges need to exercise their discretion in that scenario. And I will save any time you're willing to give me for rebuttal.
Okay.
Thank you.
Thank you, I appreciate it.
Any thought I had about practicing law in my afterlife has been extinguished today.
May it please the court, Ann Lee Moe from Tampa. It's a pleasure to be here. I think that perfect is the enemy of done on some of these rules. And I think that if there was ever a day in which a bond validation case would seem exciting and easy to understand, then I think we have provided that for you, and they can thank us later. But ultimately, I agree with what Ms. Lucas said. We all know that this court has promulgated Rule 1.010, not a rule before the court, but that rule says that all of the rules are intended to be construed to affect a just, speedy, and inexpensive result in a case. We know that. We appreciate that. I think some of the comments almost assume that we wouldn't do that, and I think that for that reason, some of the comments maybe are valid concerns but are overblown and are not remembering that we have common sense. So I wanted to talk briefly about 1.510. Thank you for doing that rule. That I think will be a tremendously helpful thing. I agree with the idea that 60 days is more generous than is absolutely necessary. For trial courts, if you were looking at something other than 60, and if you were willing to consider that, what I would propose that it would be 20 and 10. And there are two reasons for that. One of the reasons is, if I were to ask you to calculate a deadline without, in the next 5 seconds, and the deadline is 30 days from today, I think you could probably hit the nail pretty quickly. But if you add 10 days to that, if what is 40 days from today, everybody's going to have to get out their phone. So I think it'd be easier for JAs and for judges and for lawyers and for everyone to know when they can set that daggum hearing if they understand that it's 30 days instead of 40. It may seem like a small thing, but all you have to do is give yourself a series of dates and then try to off the cuff think of what's 40 days, and it's just harder. So the 20 days would allow them to have time for that response. There is no number of days that you can come up with that you're not going to have the result of someone saying, I don't have enough time. So that you can take that off the table as your matter of concern, because you already have a rule that says if you think that if the motion was prematurely filed, you have a mechanism already in the rule, and that will definitely be invoked, and it may be invoked even more now. But the reality is it's going to be invoked one way or the other. You have a good rule. You have a good procedure. 20 days should be enough. And ultimately, if at the trial court level, if we do not get committed to the idea of sequencing and spacing deadlines throughout the course of the case, then a lot of this, we're just destined for frustration and inefficiency if we don't get committed to that idea. But I think this court knows that already. I think that there's probably in the works already the idea of having a CJA for judges to talk about sequencing and spacing and case management orders. And I think that over time, even if you don't do that, we all have common sense and we all benefit from the experience of what it feels like to have to do case management where you don't sequence and space, and it's an exercise in frustration for everybody. So
What's your opinion? I'm sorry to interrupt you. What's your opinion on the tolling suggestion that Ms. Luca had?
My opinion on the tolling suggestion is that it's probably not necessary, again, because we have the ability as human beings to exercise common sense. And if someone comes in and they say this motion for summary judgment was filed 20 days or 30 days after the case was filed, instinctively the judge is going to know that there's a decent chance in that situation that it's prematurely filed. And on what planet is someone going to say, I know you filed that and you needed to get the deposition and you never got it, and I agreed with you that you should have it, but yet we're going to move forward on that hearing. I just don't think that that's likely to happen.
I think her thing was on the response time, though.
The tolling of a response time?
Yeah.
Well, I think that in practical effect, the way I just last week, by the way, one of the benefits of the conferral rule is that now my hearing time is spent. I had a day last week where I spent all day long in summary judgment hearings. That's because I do not have to have nearly as many hearings on all the things that Justice Lavarga, when you were at the trial court level, this conferral rule has changed our lives. But the reality is when someone files that motion seeking additional time, frequently that will mean that the opponent will say, okay, I get it, you've made a good point, you say you need that, I'm going to go ahead and have that deposition so that we reschedule that hearing. But for the most part, what we see in Tampa, because of the sequencing and spacing, we don't have people filing motions for summary judgment until after the close of fact discovery, because that's how we've sequenced and spaced our deadlines. And so when someone files that motion in Tampa, 95% of the time, they file the motion saying, I need more time, the summary judgment hearing can't go forward. It's the person who benefits from not having the summary judgment granted. And the reality is that you can just get out your case management order. They say they need more time for fact discovery. Well, fact discovery closed 6 months ago. So the answer is that motion's denied. Let's talk about summary judgment. So there is an interplay between all of these rules that I think this court well understands, and I think that the trial courts are really well on the way to understanding that I agree that judicial education will be more helpful, that should always be on the table, but I don't necessarily know. The problem with I think the problem with any idea that there is a mechanism by which you can stop the train from moving simply by filing a motion introduces just as many problems as it solves. So with 1.460, you've got a preview that I wanted to talk to you about that. That's a beautifully written rule. It's a great rule. The objectives of the rule are very good, are very laudable. There are two things. Number one, I agree that there is a widespread perception that the amendments to Rule 1.460 mean that trial courts no longer have the discretion to continue a case that should be continued. That's a real problem. When you hear someone say that, I want you to know from me that I see exactly the same thing, I hear exactly the same thing, and I think that that is a very real concern, particularly when we consider Rule 1.010 and the need for our rules to be construed to be a just being the first one, just, speedy, and inexpensive. I do not know exactly how this court will go about remedying that. I think judicial education is important, but I suspect that the origin story of the reason why judges have that perception is that when the administrative order came out about differentiated case management, that was a necessary, wonderful shock to the system. We then had the oral argument about the entirety of the work group's proposal sometime later. Before that oral argument, there was a very comprehensive, broad effort to educate lawyers and judges that there was this work group proposal out there, that this court wanted everyone's feedback. And as part of that education effort, I think that there was discussion about a different continuance policy than this court has actually adopted. And I think it's the residual of that has caused there to be a misperception that you are saying, or that this court is saying, that we cannot ever grant a continuance. And
the text of the rule doesn't say that.
It doesn't. You're absolutely right.
At some point, people have to read.
I 100% agree with you, Justice Kennedy. I couldn't agree with you more, but I will say this. The reason why I'm concerned, you are absolutely right. You cannot, if people are not diligent enough to read a rule, then there's no fix for that, except, hopefully we can get them when they're in kindergarten and teach them to read sooner. But ultimately, the problem we have is a very practical one. In March of 2023, in response or in anticipation of a tort reform bill that was passed here in Tallahassee, there was a surge of filings across the state. As a result, for example, in the 13th Circuit, the circuit civil docket in Tampa was doubled in a 10-day period. For circuits that took docket control measures in response to that, that has not ended up being that big of a problem. But if no docket control mechanisms were taken and put in place, what that means is that all of those cases matured in September of 2024. And the effect of that, coupled with this idea that cases cannot be continued, is that we have, if you were to ask, I think, any of the lawyers who have a personal injury practice, because those are the ones that were affected, ask any one of them, what is happening to you? And you will find invariably that there are lawyers who are next week set on 23 trial dockets across the state. And in those 23 trial dockets, they are hearing from the judges, and a certain percentage of them, I will not continue your case because the Supreme Court says I can't continue your case. They then show up on Monday morning to try the case, and of course the judge has 50 cases that are set for trial because they're all the ones that matured from March of 2023. The judge can't try all those cases, and so then those get rolled to next month. All but the one that got tried this month gets rolled. That is catastrophic. And I think that...
Why is it, help me understand why it's not in the judge's self-interest to avoid that catastrophe by actually opening the book and reading the rule and then granting some continuances. I'm not understanding why that catastrophe isn't, it's in everyone's self-interest to avoid it, so why is it not being avoided?
I cannot answer that question, Justice Coriel. What I can tell you is that whatever the reasons for it are, the experience that is occurring is what I've described. And so, again, you know, to your point, Justice Kennedy, we should all be reading. I mean, there's never a substitute for actually reading what law we're supposed to follow. And I don't mean to suggest that anyone is not reading or not capable of reading, but the other aspect of this is that while I don't think that there should be this pervasive concern that trial judges can't handle their life, because I think that you know, we all can buck up and do what we need to do, but the reality is the same dynamic that is so difficult for the lawyers is very difficult for trial judges right now. And so to say, well, under normal circumstances, you could say, well, a change in the rule, just get out the rule book, dadgummit. But the reality is that those judges are also absolutely struggling with the fact that all the cases that were filed in March 2023 matured at exactly the same pace. And so they are, what that means for all of us is that even like Tampa, we're not, we can handle it. But the reality is we get more case requests to amend a case management order because they're not all set for trial with us at the same time, but they're set for trial everywhere else and they can't get to our stuff for discovery. So we are just, what I wanted to communicate to you is we are just in a situation that I think is a different environment than was contemplated at the time that this rule was first floated. I think that the fix for that is judicial education, obviously, but then secondarily, potentially the idea of delaying the effective date of 1.460 or simply having an all-hands-on-deck meeting to explain this is a rule that everyone needs to really understand. It's pretty important. There may be a misperception.
I think we'll go with Plan B.
So with two very small things, but I think that are not small in practical effect. 1.200D, 2, F, and G. There is reference to two deadlines that are currently phrased as the deadline to resolve. The deadline to resolve objections to pleadings or the deadline to resolve all pretrial motions. A deadline to resolve is a deadline for the judge. That's what the 13th Circuit interprets, that's our deadline to rule. But we rule on things when someone sets them for hearing. So that may be a difficult rule for us to enforce. If that were tweaked to say that the deadline is for the deadline to file objections to pleadings and to file pretrial motions, that's easier to resolve, easier to actually enforce, provides a meaningful cutoff for things that we need to cut off, but also where if there's potential for ambiguity, if the court agrees that there's some room for everyone to be confused about what does the word resolution mean, and is that the same thing as filing or is it the same thing as deciding, the impact and the import of that is that there is about a 60 to 90 day swing in when that deadline should fall logically. A deadline to file should obviously fall sooner than the deadline to resolve.
Which rule was that?
That was 1.200D2, subsections F and G both have the same thing. And I think that with regard to objections to pleadings, that in the 13th Circuit we actually had a much longer debate than you would ever imagine about what is an objection to pleading. And I think that what that means is a motion to dismiss or a motion to strike. If what was intended was motions directed to pleadings, if that's what objections to pleading is intended to say, I think that it would be worth considering whether or not just to say motions directed to pleadings instead of objections to pleadings. I thank you so much for your time, and I appreciate your patience. Thank you.
Thank you. We appreciate your comments.
May it please the court, the business law section filed a very short, narrow motion just supporting the inclusion of proportionality in the modified scope of discovery. And I'm here to answer any questions if necessary, but I'll just very briefly touch on a couple things that are helping with the efficient resolution of these cases. We all have trepidation about change, and I think that's part of the concern about proportionality, but the federal courts have been applying this pretty successfully for 10 years, and there's a great body of case law about that the Florida practitioners, I'm sure, will be able to read and can use for the courts to make these decisions. This is just a tool to resolve the cases, the disputes that are already happening. And the benefit of having this here is the practitioners, when drafting their discovery requests, have to do so with proportionality in mind, and that will help reduce some of the disputes because you're working on it on the front end, not the back end. Again, this is the method for how these are being decided will stay the same, but Justice Labarga, if there's a boilerplate objection, the sanction for that is it's most likely going to get denied as being unsupported. So if along those lines, as this Rules Committee has proposed and the section has reviewed and agrees with the proposed changes regarding requiring specificity in 1.340 and 1.350. We support those and think that will help also reduce the occurrence of boilerplate objections. So with that, unless there are any questions, we support that inclusion, and we appreciate the court for your time.
Thank you very much.
Good morning, Your Honors.
Morning.
My name is Karen Gievers, and today is the 46th anniversary of my becoming an attorney.
Great.
I can't believe the time went so quickly, and thank you for letting me mention that. I'm here this morning on behalf of the Florida Justice Association, essentially the plaintiff's bar. Our members have cases in all 67 of Florida's counties and all 20 of the circuits. And I've also had the extreme privilege to serve as a circuit judge here in the Second Judicial Circuit for a little over 8 years, from 2011 until I aged out in April of 2019. I served in all of the different divisions during the time I was on the bench and saw from the judicial trenches how life differs for our trial judges in a rural city or county versus a big city, and the expectations we have, because generally people on the trial bench don't come from a singular background. We have folks who were state attorneys, folks that were public defenders, people that did family law, maybe dependency, that's generally very rare, some circuit civil, but all backgrounds. And very few of those backgrounds included anything to do with the federal practice. So familiarity with federal rules, case law, et cetera, is something that is not part of the normal acquired knowledge to that point. Even in a small county like Jefferson, there could be an event such as where a tourist gets murdered at a rest stop on I-10 that becomes all-consuming, and there's only one circuit judge assigned as a part-time assignment to handle every division at the circuit court level in Jefferson County. That judge does not have time on his or her hands to be looking at proposed civil procedure rule changes that will affect the circuit civil cases in that county. Everything is the responsibility of that judge, and when you have a high-profile event, then everything suffers. Another thing that our trial judges do not have is a single law clerk lawyer dedicated to them. Each circuit has some, usually 4 or 5, that handle unusual cases or habeas corpus issues or prisoner petitions, but no circuit judge that's in a circuit civil division that I have found has their own dedicated law clerk. And the concerns that the Florida Justice Association has, there are some members, of course, who would prefer not to add the proportionality rule in there, as the comment mentioned, but if we're going to bring in a federal concept, then we should have the resources that the federal system has so that we are not overburdening our already overburdened, whether due to COVID or legislative action or whatever. Our circuit judges work hard trying to do the jobs they are to do, and they often involve more than one assignment in one division. I know that those judges that get assigned to a division like dependency, where they may not have had experience, they get a system-prepared bench book. It lays it all out. Easy reading, helps them understand what they're supposed to be doing as they handle that social work division and help try to get families reunified or terminate parental rights and get children adopted. Each division has different rules. You all are just amazing to be able to handle all the different rules and make sure everything flows seamlessly, which is the hope. But from the standpoint of the Florida Justice Association members and the others who have spoken, all of us have one thing in common, which is we want our trial judges that are handling circuit civil cases to be able to give them the time and the attention that they need. And that includes thinking time. It doesn't include it should include time to read every memorandum of law that's submitted on a motion to compel or something, and then read the response and have a law clerk or somehow time to see if anyone miscited cases or God help us if we get into artificial intelligence and we find out the artificial intelligence is manufacturing cases that don't exist, as happened in an incident that has been widely reported on in some of the attorney seminars. We have to be vigilant. We have to provide justice to the litigants in front of us. Everyone needs to be treated fairly. And so I don't know how you put the extra burden of the discovery and the motion practice that will inevitably follow the proportionality if there aren't two things that happen. Number one, there needs to be a proactive education outreach to the trial judges that are going to be responsible for handling this, so that on whatever day the new rules become effective, they know that, as you did with the summary judgment rule when you switched to the federal standard in 2021, that you're switching to the federal standard, which cases they should look at. If you're not comfortable adopting the federal advisory notes or committee notes, at least prepare a bench book, because those trial judges that are in the courtrooms right now or having their assistants try to find hearing time for somebody to have something heard, they don't have time to be looking at all the case law that interpreted the federal rules and advisory notes. There's just not that time, and they don't have, unlike the magistrates, they don't have magistrates. The federal magistrates have law clerks. Anyhow, you get the point. There is no reason that we cannot all work together. If we're trying to become more like a federal system, we can work together to get the legislature to fund a federal type system. But if you're going to overload the judges, then none of the parties that are going to be practicing in front of them, everybody trying to comply with these new rules, will be in a position to meet your time standards. So the second thing, resources. The other thing is sanctions, because without sanctions and a means of enforcement, whether it's an admission of a fact or monetary sanctions on a party or lawyers, people have to see that you think the rules have meaning. There's a game that many of us play as children called telephone, where you line a bunch of children up and you whisper something to the first person and they pass it down the line. And by the time the last person hears it, it has no relationship to what was intended and what was said at the beginning. I think in a way, the panic that was referred to regarding the judges can't grant continuances anymore comes from people that don't have time to read and think about the rule change, and they don't understand what good cause means, and there's just no time for anything, it seems like, because we have gotten more remote from each other, first because of COVID. We do save a lot of time not having to drive from one end of the state to another for a half an hour hearing. That is a big help, not being on the road all that time. But it means
more time you would think to read the rules.
Well, there's that too, and I don't know how, I haven't seen criteria for folks to pass a competency test in a particular division before an assignment is given, but that sounds like it would require rules.
I guess so.
And
we don't pick the judges, so the people get to elect them.
Exactly, I understand that. I'm just trying to figure out a way and suggestions, having been under the pressures that go with, and I've been board certified as a circuit civil trial attorney for almost 40 years. Next year will be the 40th year as a board certified attorney. You would think I would have no trouble handling a circuit civil docket. The last 4 years I was on the bench, I had circuit civil docket, occasionally doing some other things, and there's still things that I'm finding now that I'm a semi-retired electronic lawyer, not letting my law degree go to waste. The rules are interpreted so differently by so many different people because they're interpreting them with their backgrounds. And they come from different backgrounds, and they practiced in different size firms, and they went to different mentors, and they learned different things. So the more clear your rules are, the better for all of us. And one last little point, effective date. I checked when the major rewrite occurred I thought it was the 60s. It turned out it was in the 50s. They started looking at it in 1952, Justice Kennedy, and it took them until 54, June 1st of 54, to go from 141 rules to 82 rules. And what they did was they made the new ones applicable to the cases filed on or after that effective date, and they left the old rules in effect for the ones that had already been pending. Well, that works on some, but I don't know if you want to make the initial disclosures something that has to happen immediately, but the duty to supplement probably could be made effective immediately. So however you're going to do it, I think the more precise you can be in the rule language and the more attentive to the education inevitably that anyone who is a circuit civil assignment will understand, oh yeah, and did I mention judicial rotations every 2 years?
I'm sorry, could you take 30 seconds to wrap it up?
Yes, thank you. Anyhow, the fact that judges don't stick in the same assignment, they rotate, and that means you're going to have to re-educate new people. The clearer the rules, the better. And thank you for the time, and thank you for letting me be here.
Thank you, and congrats on the anniversary.
Thank you.
Did you have rebuttal, or not rebuttal, but?
I had the privilege to speak to Judge Moe beforehand, a conferral of sorts, and she made known the concern she had about the issue with continuances. The committee had considered that. I think I know the court's not inclined to obviously delay implementation. Obviously, additional education and perhaps the final opinion. Maybe it could be as simple as read the rule when that's not what we're saying, but a small word may go a long way with this issue to help give a little bit of guidance.
Okay, thanks so
Thank you.
much. We appreciate it.
I promise I will be brief. Judge Grosshans, I think you're my audience on this one, so I'm going to look at you a lot. 20 days is not sufficient to respond to a motion for summary judgment in a complex case. There's nothing about Rule 1.510 that makes it special for complex versus general versus streamlined. 20 days defeats what I said about using summary judgment as a tool to bring about settlements. Settlement is the highest and best outcome for any case. It's off the judge's docket. You know, there's a movie, Shark Tale. Are you happy? No. Are you happy? No. Great. That's the best resolution. And it's a tool that I see used so often. 40 days ain't broke. Please don't fix it. I strongly advocate for 40. As for Rule 1.510D and the tolling, respectfully, if filing a motion under 1.510D doesn't stop the train, what's the point of having Rule 1.510D? And actually, I meant to bring the book with me. It says, Justice Coriel, I noticed you had your book up there with you. If a non-movement shows by affidavit or declaration that, for specified reasons, it cannot present facts essential to justify its opposition, the court may defer considering the motion, deny the motion, allow time to obtain affidavits or declarations or to take discovery, or issue any other appropriate order. If filing that motion to ask for that relief doesn't stop the summary judgment train, then why'd you create the rule? You have to have the tolling provision, otherwise the rule doesn't make sense. And Justice Kennedy, to your point, the same lawyers who don't do a good job reading become the same judges who don't do a good job reading. And I specifically wrote down...
I probably shouldn't say this, but I'm going to.
Don't.
I wonder, and I don't, this is not an accusation, but I wonder how much of this could be sort of passive resistance from folks that really don't like change and don't like the new rules and don't like the kind of the pressure, which is there. And sometimes people that don't like rules will implement them in a way that is least likely to make them successful.
Well, sometimes people don't take the time to do the continuing education, to read the articles, to stay on top of things. Some people like the easy way to clear the docket. If I'm not going to grant a continuance, it's going to put a squeeze on the lawyers and they're going to have to resolve it, or it's going to move off my docket. The motivations can be wide and far. But Justice Muniz, when you asked Judge Moe if there needs to be a tolling provision, she said it's probably not necessary and instinctively a court should know. And my response to you is probably not, and instinctively are the words we use as lawyers when we can't be absolute. And you can't have an absolute here because all judges are going to interpret things differently. And like I said, you created 1.510D for a reason. if you're going to give effect to it, it needs to stop the train. And my question to you is, where is the harm in making that clear? It is unfortunate if it takes too much time. There are some jurisdictions where you can get 5 minutes in the morning to ask the judge to call it to their attention that you've got a 1.510D motion pending, and other jurisdictions you can't. It varies wildly, but I feel very strongly that there will be chaos if, based on differing interpretations by different judges in different locations, if you don't create the uniformity in the rule. And my last point is on funding. I have toured the state talking to judges and talking to lawyers and trying to prepare them that these rules are coming and that they need to be adjusting their practices and how they're thinking. And I have asked judges, because they are stressed, what would make it possible for you to implement these rules the way the court's envisioning? And the two things I hear over and over again are case managers and law clerks, and they don't necessarily agree. I talked to judges yesterday in Broward County, and they said, law clerks, we need law clerks. If we had law clerks, then we could administer things so much more efficiently. But then judges in Seminole County said the case managers are what we need. There was a judge who said, I have 300 orders sitting on my desk that need to be signed, and I don't know when I can get them done.
The thing about it is law clerks can't sign those orders.
Law clerks can't sign those orders. You're absolutely right.
I have great law clerks, but they can't do that.
I don't think they're suggesting it. I think that what she was suggesting was, if I had law clerks that were doing other things, it would free up my time to...
I understand the argument. I definitely do. And I wish everybody could have law clerks as great as mine. But, you know, I think part of the colloquy about resources that, and I don't want to delay this any longer, but I do think this is an important point. I don't think it's fair to say, well, federal rules means federal resources. I think that if there is a better mousetrap, I don't care whether it's a federal rule or one we came up with, it should actually lower the demand for resources. We should be, you know, in this posture, thinking of rules that minimize the demand on resources. And if a federal rule happens to effectuate that, great. You know, and if a state rule we can come up with effectuates that, great. I think, you know, in our consideration of this, I think we should break down this idea that, you know, if the federal rules have come up with a better mousetrap, that mousetrap will only work if everybody has 4 law clerks and lifetime tenure.
I'm not advocating for 4 law clerks and lifetime tenure. What I am advocating for is that I believe right now is the time to ask the legislature. The Florida Bar has almost 100,000 members the last time I looked. Let's say 50% of them are impacted by these rules. You're talking about tens of thousands of lawyers. If the sections of the Florida Bar that touch civil justice united, I know FLBOTA is on board, I know the FJA is on board, and I'm positive that the FDLA will be on board, because what we all want is the same thing. It is bipartisan. It's not Republican, it's not Democrat, it's not plaintiff, it's not plaintiff, it's not defendant. It is, we want the civil justice system in Florida, state courts, to operate smoothly. And I think that a request like that hits the legislature differently when it's supported by the Florida Supreme Court. I think this moment in time is lightning in a bottle. We have a newly elected set of state legislators and senators. We have committees that are realigning, and we should probably know within the next 2 weeks who the members of those committees are going to be. And this is an issue that makes everybody look good. Which legislature wants to say, I oppose helping the civil justice system? So it only takes a spark to start a fire. And I am handing out sparklers to any group that will listen to me when I go try to talk to them about these are the rules and how they're going to impact your practice. This is what you need to be doing to prepare yourselves. And I believe that with your support, we can create a fire that burns so brightly that the legislature can't ignore it. And I would ask that when the request is made, that you strongly consider supporting a request to give funding to the individual circuits so that they can determine what best suits their circuit to implement the rules, because we all want the same thing.
Okay.
Thank you.
Thanks so much, and thanks for all your work on this. You've gone above and beyond the call of duty. We appreciate it. We're going to take a 10-minute